And now a mini debate on Proposal 2, the statewide ballot proposal dealing with affirmative action. Here's David Hecker and Jennifer Gratz. Ms. Gratz, let's start with you. Explain in 25 words or less what this ballot proposal does.
Voting yes on Proposal 2 ends programs that grant preferential treatment based on race or sex in public education, public contracting, public employment. It would end programs like the Pontiac Fire Department's program, where 1 out of every 3 promotions is set aside for a minority. You can't even compete if you're not a minority.
Why is this on the ballot?
It's on the ballot because we believe that people should be treated fairly. We believe in the original meaning of the 1964 Civil Rights Act. We believe that people should be judged on their merit and their character when competing for jobs, competing for college admissions, not their skin color or their sex.
Mr. Hecker?
Proposal 2 is brought to us by California money in an attempt to change our Constitution. It would roll back progress we made in providing opportunities for girls, women, and people of color. It would roll back building a more diverse state. Proposal 2 is opposed by an amazingly broad, diverse coalition, and I think that says a lot. Democratic Governor Granholm, Republican challenger DeVos. Democratic United States Senator Stabenow, Republican challenger Mike Bouchard. Big 3, chambers of commerce, organized labor, religious organizations. Proposal 2 would roll back the progress we've made. To reference the 1964 Civil Rights Act in a way that Ms. Gratz did totally takes that act out of historical context. That act was made into law because of discrimination primarily against African Americans. And that's why that became law.
Do you believe there is discrimination in this state against white people?
I think there's discrimination in this state against white women, white girls, yes.
Do you agree with that?
Well, I think that there's discrimination going on. Yes, I do. I think that these policies, and the Supreme Court agreed with me here. The U.S. Supreme Court said that the University of Michigan discriminates. They made them end that policy. The U.S. Supreme Court also said that discrimination is okay for about another 25 years. That's what the Grutter decision amounts to. I think most people disagree with that. I think most people believe in the original intent of the 1964 Civil Rights Act, which was to treat people without regard, and I emphasize that, without regard to race. The policies that we're talking about today treat people with regard. The University of Michigan, the Pontiac Fire Department, they admit that these policies treat people with regard. To couch these policies as equal opportunity is completely false. These policies allow for an unequal opportunity. They're discrimination and they're wrong.
Do you agree that originally these policies were needed to level the playing field?
I think that policies, true affirmative action policies, when we get back to the original meaning of affirmative action, and again, all we have to do is go back and read the language of the executive order from Kennedy. It flat out says, treat people without regard. So policies that make sure that testing isn't biased towards one group or another, whether it's testing to become a police officer or testing for college admissions.
That wasn't my question. Originally, when this proposal, affirmative action, was out there, was it okay then, but it's not okay now?
Well, but it's not affirmative action. I don't believe that these policies are affirmative action. These policies are preferential treatment and they're discrimination. When you prefer one group over another, another group is going to be discriminated against.
Was it
That's
wrong then originally to give this preferential treatment?
I think preferential treatment's wrong.
So the policy was wrong in the beginning and it's wrong now, but you just said that it was okay to go for 25 years and then change. So which is it?
That's what the U.S. Supreme Court said.
But do you believe that?
No. I think that the Constitution, I don't see how the Constitution changes in 25 years. I think right now these policies are unconstitutional. The Supreme Court said in about 25 years these policies will be unconstitutional. Our Constitution doesn't change like that.
Isn't it basically inherently unfair to say somebody gets a leg up when somebody else doesn't?
You know, when I drove up here, Tim, I drove by Okemos High School. I spent a great deal of time in high schools, in Ecorse, in Highland Park, in Detroit, in Inkster. There is no comparison between the two. Great teaching goes on in those falling apart, dilapidated school buildings, but if this was a society free of discrimination, let's have a discussion. This is not a society free of discrimination. The way our K-12 schools are funded does not treat every child equally.
The question was, is it inherently unfair that one group gets a leg up while the other group does not?
This does not do that. Affirmative action creates a level playing field.
Well, some would argue, I believe. Okay, well, in fact, let you argue it.
Well, I mean, he's talking in circles. He's talking about schools. He's not talking about race. He's talking about socioeconomic status. So let's go ahead and take that into account. Let's let the government help people that really need help, that haven't had all the advantages. But let's do that across the board for all people of all skin colors. A white student, an Asian student that goes to, for using your example, E-Course High School, should get the same benefits that a black or a Hispanic student does.
Let me just stop on that. Do you agree or not?
I agree. Everyone should have the same opportunities. The problem is, in our society, given a history of discrimination, people do not have the same opportunities. The Supreme Court said that. The Supreme Court said these programs are needed to level the playing field. We still need these programs to operate to level the playing field for people of color, girls, and women.
I completely disagree. And as a woman, I find it very offensive that a man would sit here and say that I need a preference to get ahead in society. The Supreme Court did not exactly say that. In fact, the Supreme Court pointed to California, to Washington, to Florida, to Texas, and said these states have engaged in programs that are race neutral. Their term, not mine, race neutral. And all states can and should be moving in that direction. That's what the Supreme Court said. It's time to end these policies. It's time to vote yes to end these policies so that people can be treated equally.
That all women are not like you, that did not have access to the same opportunities that you had?
What opportunities are you referring to?
Well, did you apply to the University of Michigan?
I did apply to the
Did you get a high school education?
I got a high school education.
Did you have parents that wanted you to succeed?
I had parents that wanted me to succeed.
Well, there are some people out there that don't have all of those.
Well, but again, that's not to be fixed at the college education level. And there's a lot of misinformation about me out there. Neither of my parents went to college. My dad was a police officer. My mom started as a secretary. I was the first in my family to graduate from college. And for you to sit here and say that women benefit from these policies, well, you fought against women every step of the way. When a woman sued the University of Washington for race discrimination, the same organizations that are against this initiative were against her. When a woman sued the University of Texas for race discrimination in their admissions policy, same organizations against her. When a woman, 3 women actually, sued the University of Georgia, same organizations against them. And then 2 women sued the University of Michigan. You specifically spoke out against us women that sued the University of Michigan. It's hypocritical for you to sit here and say that women are the primary beneficiaries of these programs when you've been against women every step of the way on this issue.
Well, I enjoy personal attacks. I have no idea what Ms. Gratz is talking about. I have never spoken out about any of the things that Ms. Gratz is talking about.
That's completely false.
Well, you show me the articles where I'm quoted. You show me the newscasts where I'm quoted.
You took your kids down to the U.S. Supreme Court to be against the affirmative action lawsuits. You took your kids down there, and you were quoted as being against the lawsuits.
We are my family, the labor movement, an unbelievably diverse group of people support affirmative action.
So you were against the women that were challenging these policies.
We're for affirmative action. We're for a playing field, an equal playing field.
Why don't you want to answer that?
Because, I mean, the question ignores the facts. The facts are that women make 67 cents on a dollar for every dollar a man makes. The fact is that 5% of the top 500 officers of the top 500 Fortune 500 companies, only 5% are women. The fact of the matter is that an African-American male makes 25% less than a white male, with the same education level. The facts are clear. There is discrimination in this society against girls, against women, against people of color.
Do you agree?
His facts are wrong. I mean, an independent report just came out a couple weeks ago by the Citizens Research Council. By 2001, females earned an average of 92 cents for every dollar earned by males. This figure was 76 cents in 1977. In 1984, minorities earned 94 cents for every dollar earned by a minority employee. In 2001, that figure rose to 99 cents for every dollar. When his facts are wrong, can his opinion ever be right?
Facts wrong?
Right. No, facts are right.
We're going to agree to disagree on that.